Challenging a will is a complex legal process that requires substantial evidence and a clear understanding of the legal grounds on which a will can be contested. Below is a detailed guide on how to challenge a will, including the grounds for contesting, the legal process, and potential outcomes. Grounds for challenging a will. To successfully challenge a will, you must have valid legal grounds. Common grounds for contesting a will include 1. Lack of testamentary capacity definition. The testator, person who made the will, did not have the mental capacity to understand the nature of the will, the extent of their estate, and the impact of their decisions at the time the will was executed. Evidence. Medical records, witness testimony, and expert opinions may be used to demonstrate lack of capacity. 2. Undue influence. Definition. The testator was improperly influenced or coerced by someone to make or change the will in a way that does not reflect their true intentions. Evidence. Testimony from witnesses, documentation of the influencer's behavior, and circumstances surrounding the will's execution. 3. Fraud or forgery. Definition. The will was signed by the testator due to deceit or misrepresentation, or the will is not actually signed by the testator. Evidence. Handwriting analysis, expert testimony, and documentation demonstrating fraudulent behavior. 4. Improper execution definition. The will does not meet the legal requirements for execution, such as lacking the necessary signatures, witnesses, or notarization. Evidence. Examination of the will document and testimony from the witnesses or notary involved. 5. Revocation definition. The will was revoked by the testator before their death, either by creating a new will or by a deliberate act such as destroying the will. Evidence. Prior wills, documentation of revocation, and testimony from individuals aware of the revocation. Legal process for challenging a will. 1. Determine standing eligibility. Ensure you have legal standing to contest the will, typically as an heir, beneficiary, or someone who would have inherited if there was no will. 2. Consult an attorney legal guidance. Seek advice from an experienced probate or estate attorney to understand the strength of your case and the legal requirements in your jurisdiction. 3. File a petition initiate proceedings. File a formal petition with the probate court challenging the validity of the will. The petition should outline your legal grounds and evidence. 4. Notify interested parties service of notice. Notify all interested parties, such as beneficiaries named in the will and heirs, about the filed petition and upcoming court proceedings. 5. Gather evidence documentation. Collect and organize all relevant documents, including medical records, previous wills, financial statements, and correspondence. Witnesses. Identify and prepare witnesses who can support your claims, such as doctors, friends, or family members. 6. Attend hearings court appearances. Attend court hearings where you and other parties present evidence and arguments. The probate judge will consider the evidence and determine the validity of the will. 7. Mediation or settlement. Alternative resolution. Consider mediation to reach a settlement with other parties involved. This can often be a quicker and less contentious resolution than a prolonged court battle. Potential outcomes of a will contest. 1. Will upheld, valid will. If the court finds the will to be valid, it will be admitted to probate, and the terms of the will are carried out as written. 2. Will invalidated void. Will. If the court finds the will to be invalid, it may revert to an earlier valid will, or, if no prior valid will exists, the estate may be distributed according to state intestacy laws. 3. Partial invalidity. Partial changes. The court may find certain provisions of the will invalid while upholding the rest, leading to modifications in the distribution of the estate.